Well, this one started out just as a interesting sentencing case with a funny judge. And then I looked up the guy's charges and realized he's a garbage human being. So now it makes it a little more interesting. So this is Buddy Deacon's motion to set aside his plea agreement that he made back in May, I believe. You see, in 2021, he was arraigned on 10 charges. 9 of them were criminal, contact with an individual under 13 years old. 9 counts. And a 10th count of criminal contact in the 3rd degree of a person between the age of 13 and 15. The offense date is 2007, and like I said, he was arraigned in 2021. This case has been ongoing since 2021. The penalties for all of those sentences we just talked about is 25 years to life for each one. I imagine they would run concurrent. If he had a previous conviction, which I wasn't able to find, but I didn't really dig too hard, a mandatory life sentence. And 25 is a hard number. You can't fluctuate from that. And after he was released, he would be required to have lifetime monitoring. So the plea deal he took is 6 to 15 years running concurrent for counts 9 and 10 with the rest dismissed. 6 to 15 years. He was facing 25 to life, and he took 6 to 15 years with no monitoring afterwards that I could find. I mean, it might be possible that they wrote that in there, and now he wants to dismiss that and go take his chances at trial? So his attorney's arguments are kind of interesting. So here we go.
All right, what do you want to start with?
Your first matter would be People versus Buddy Deacon, which is file 21S28550FC. Mr. Deacons is present in the courtroom with his attorney. We are here on the defendant's motion to withdraw his plea.
This file.
Yes, Judge, sorry.
Thank you. Mr. Ortiz, go ahead, sir.
Thank you, Your Honor. As the prosecutor stated, Your Honor, this is set for a motion to withdraw my client's plea back in May. The Friday before the trial, my client was out on bond, was set to meet with his attorneys, was unable to do that. He was sick, he had high blood pressure. He had to go to the hospital. So he met with his lawyers on Saturday regarding this case. That following Saturday, what came out of that meeting on Saturday was that my client was not in agreement. It was not going to plead to the offer that was presented by the prosecutor to them. He still wanted to go to trial. He's always professed his innocence to his 2 lawyers. And following that meeting on that Saturday, the only thing that was resolved out of the meeting on Saturday, according to my client, was that he was prepared to go to trial. He was not on board with the offer that was presented. He repeatedly told his lawyers that he was innocent of the charges that are brought against him. So that on the following day, on Sunday, there was phone contact again with his lawyers. My client did again, it's outlined in his affidavit that's attached to my motion, that he was not going to accept the offer that was presented by the prosecutor. He still wanted to go to trial. He professed his innocence again. And then on the Monday morning of the trial, when the jury was present, my client met with his lawyers for a short period of time, and as outlined in his affidavit, he felt like he was really forced to plead. They told him that if you don't plead, you're going to prison for the rest of your life. And that I think that worried him. Also, after the plea was presented at the jail, his blood pressure was out of whack and his sugar was out of whack, and that's confirmed by the jail nurse. Having said that, I think it all goes to my client's mindset that he was told that if you told the judge you wanted the trial adjourned, that he would get mad at you. He felt at that point he had no choice no choice but to take the offer presented by the people, the plea transcript. The court did go over his rights with him. He agrees with that. That's what happened. Although he was not, I don't think he was totally understanding what was going on in the case. And again, he felt like he had to do what he had to do. So that's the background. But what adds to the really mix in this case is that when my client was remanded to jail, at some point, either that Monday or the following day, he received a letter. I attached it to my brief, my motion, and that letter outlines my client's thought process from his lawyers. That in that letter states that I understand that you have not made a decision yet on the plea offer that we reviewed with you. Please let me know if you make a decision before Monday morning. We'll be prepared for trial if you choose to reject the plea offer. However, they felt strongly it was in his best interest to accept that offer. And what's interesting about this letter is that it's dated May 20th. My client did not receive this until he was in the jail. He took his lawyer to task about this letter being backdated, and and apparently that discussion did not go too well. He did not get an answer from his lawyer when he confronted her that this letter was backdated. And again, in this letter, it also states, finally, you mentioned this morning that you may want to review some of the discovery again. I understand because of your reading disability, you may want to have those documents read to you. I'm available anytime to reread any of the discovery documents to you. Please feel free to call me. My client's position is that when I look at this letter, it's backdated. He doesn't get it till he's been remanded to the jail. I find that very interesting, but it shows my client's mindset, Your Honor, that he really did not want to plead. He wanted to go to trial. He found out that many of his witnesses were not, were called off. A lot of his witnesses in his defense were not interviewed. And when I reviewed the file in this case, it's a comprehensive file by the defense. And it was a very good job of preparing the case for trial. A monstrous file with a lot of things that were done and which were done good. Something happened on that weekend before the trial, and something happened on that day that he pled. He just didn't. It does not make sense. Everything that was going on and all my statements my client is making, that he really understood what he was doing. Looking at the standard for a motion to withdraw the plea before sentence, a plea may be withdrawn on the defendant's motion or with the defendant's consent only in the interest of justice. It may not be withdrawn if a withdrawal of the plea would substantially prejudice the prosecutor because of reliance on the plea. Mr. Valet answered that paragraph 37 in my motion. The withdrawal of the defendant's plea would be in the interest of justice and would not substantially prejudice the prosecutor in accordance with the court rule. The only response was that from the prosecutor that was not true. So there was no prejudice that were put forward by the prosecutor that they would be prejudiced by this case by my client withdrawing his plea because of the reliance on the plea. And it has to be substantial prejudice. So we look at this case, my client's mindset.
Before we even do that analysis, though, don't we have to first consider the court rule, and there has to be an error in the plea taking process? Because in paragraph 39, you said there are obvious, those are your words, obvious errors in the plea taking proceeding. Show me where those are.
Understanding plea.
Show me where the errors are, though.
Well, I'm just saying, in the transcript.
Yeah.
Well, it's again, every motion withdrawal plea always has a transcript that says that.
Well, what I'm getting at, an error would be, did the court neglect to ask any of the required questions? Did your client answer in a manner that would suggest he did not know what was going on, or that he was coerced, or that he had a medical condition? None of that occurred.
Well, I'm, post plea, all those things in his mind, he didn't understand it. He felt like he had to do it. He was told that not
Well,
to.
of course, that's what he says today.
Well, that's,
He has buyer's remorse, right?
I don't
But
think it's, I
they're
don't,
your words. As an officer of the court, you have said there were obvious, not just errors, but obvious errors in the plea taking proceeding. I'm asking you to point them out to the court.
well, the obvious error is that based on his affidavit, he didn't understand. It was not an understanding plea.
So 39 is not accurate, what you wrote then.
Well, I would say it's obvious that he didn't understand it based on my,
Well, I'm not trying
discussions.
to play games, Mr. Matthews, but I'm asking you, point out in the transcript where the court made an error. I'm not asking you to tell me what your client thinks today that he didn't understand. I'm asking you to back up what you wrote in your motion here, which says there were obvious errors in the plea taking process. Because I don't see those. And if they're so obvious, either I'm an idiot or you're a genius and I'm a really an idiot because I don't see it. Mr. Valet didn't point out any errors. I would think if there's anybody that was most interested in getting this right, it would be the people. They don't want to come back and have a trial. He didn't see any errors when he reviewed it. I didn't see any errors when I reviewed it, and I certainly didn't see an obvious error. I didn't see an omission where the court didn't ask him something. It was a lengthy process. It went on for some time, and the court went to great lengths. Asked Mr. Deakins, do you have any questions about what we're doing here today? No.
Yep, and that is accurate in the transcript. But if you still look at the court rule, again, in interest of justice, when you talk about buyer's remorse, I don't think it's really buyer's remorse. He got, based on the charges, he received a.
But let's just be clear, because you keep dancing around the question. There are no obvious errors in the plea taking process, are there?
I would say that he didn't understand it.
You're dancing around the question. There are no obvious errors in the plea taking process as you cited in paragraph 39. If there are, we need to talk about them because I want the reviewing court at some point to be able to hone in on it. I would like to be able to hone in on it because those are your words, they're not mine. And if there's an obvious error, then you might be on to something. But you keep telling me and dancing around the question that it's Mr. Deakins' mind that we should be thinking about, that he didn't understand the process.
Right.
But before I can get to whether he understands the process, don't I have to look at the court rule, which says that we have to take a plea in accordance with the court rule? All right. And so if I do that, the reason we have to do that and do it minus these errors is then this argument about understanding, knowing, and voluntary doesn't become an argument. It's set up that way so that we head off these kinds of things up later on. You know what, Judge? I didn't understand. And that's why I asked, I don't have the transcript in front of me. That's why we see at the end of a plea, when I ask your client, and I don't have it in front of me, but I would guarantee I said, Mr. Deakins at the end, do you want the court to accept your pleas to these two charges? And his answer was yes. And then the court has to finish by court rule with the language that says, Mr. Deakins, I will accept your pleas. You have offered these pleas freely, accurately, and voluntarily. So again, Mr. Matwyzik, if there's obvious errors in the plea taking process, point them out. Don't dance around the question. Get your transcript out, show the prosecutor, show the court, so that a reviewing court can say that I either got it right or I got it wrong. It can't just be, wait, it's Mr. Deakins thinks he didn't understand. That's not an error in the process. Maybe it's a concern of your client, but it's not an error in the process of taking the plea.
Again, that's my final answer, Your Honor, but if you look at the court rule,
It's not jeopardy.
if you look at my court rule, look at the court rule, MCR 6.310B1. Again, withdrawal after acceptance before sentence, except as provided in subsection after acceptance but before sentence. Number one, a plea may be withdrawn on defendant's motion or with the defendant's consent only in the interest of justice, and may not be withdrawn if the withdrawal of the plea would substantially prejudice the prosecutor because of reliance on the plea. This next sentence, if defendant's motion is based on an error in the plea proceedings, the court must permit the defendant to withdraw the plea. So looking at that part, my position stays the same. I don't believe he understood it. I know the court's argument, but I think that when you look at, again, everything that happened and what he was told is outlined in his affidavit and in my motion, I think in the interest of justice, and there's no substantial prejudice. There's no prejudice at all for him to withdraw his plea. As far as buyer's remorse, again, the agreement, as presented by the prosecutor based on the charges, quite a drastic reduction. My client understands, he understands that.
It was a substantially drastic reduction.
Right.
I mean, Miss Reed didn't give him any inaccurate information, did she? He was facing several life offenses with 25-year mandatory minimums. I mean, there's an argument here to be made that your client is getting the deal of the century.
And then one has to wonder why that is, because he professed his innocence, and I think that.
Well, maybe it could be as simple as the victims didn't want to go through a trial, but after hearing their statements at sentencing, I wouldn't want a jury to hear those statements either. I don't remember if you were here for their statements, Mr. Matoizik, but wow, they were fantastic.
And I discussed that.
And I really would not want a jury to hear that if I'm in Mr. Deacon's shoes.
And I discussed that with my client. And it's his position, he still wanted to withdraw the plea. I discussed with my client that he could be convicted on everything and get stacked on 25 minimums, mandatory minimums. He understands that as well. I think that goes to his mindset that he's professed his innocence, and there's much more to the case than simply what they said at sentencing.
Anything else, sir?
No, Your Honor, thank you.
Mr. Valitt.
I think that first of all, I think the court has to base upon the record, and the record we have is the record of the plea. I don't think this affidavit and Mr. Matoizik's position on what happened is what the court reviews. I think him simply filing an affidavit isn't enough. He makes all kinds of claims that says, I got backdated letter, I got this, I got that. I don't think that's sufficient. All of that said, Judge, I think the standard is twofold. You have to find that it's within as I indicated in my brief, the case law indicates that may is the operative word. The court may, in its discretion, determine that plea can be set aside in the interest of justice. My position is they haven't met any of that burden of showing us why. It's clear to me from reviewing the 20-minute procedure that we basically had in taking the plea, that's the amount of time it took for us to do it. 20 minutes that he was responsive to all questions that were asked to him, that he knew what he was doing. He was advised not once, but multiple times of what he was doing by the court. There was never, he asked not one question. He had two attorneys, both of which are skilled attorneys, and gave him what I believe, based upon the offer and the possible settlement, I believe they gave him excellent advice in taking this plea agreement. So the issue I think we're here on is he simply changed his mind, and I'm not sure that is a basis upon which to say it's in the interest of justice. He knew what he was doing. He was receiving good advice. He didn't give any indication that he was in medical distress. And if you take their argument in the broadest sense, that's the three issues that are in there to say why they should be able to withdraw the plea. When he decided to enter a no contest plea, he said, I'm choosing not to contest the facts of this case. The court reviewed the police report and the two supplements and found that there was a basis for the plea. So what we have, in my opinion, is we simply have, I think buyer's remorse perhaps is an appropriate term. He simply has changed his mind. Now that nothing was filed until after we were scheduled to go to sentencing, and I appreciate that the argument here is that he wanted his lawyers to do something they didn't. I think if that's the case, there has to be an evidentiary hearing to find that. But everything that I see from the outside, it looks to me that his two attorneys acted with great prudence and gave him very good legal advice in this matter, and that he clearly understood. He clearly understood, and he responded in the affirmative every time the court asked him. I mean, the one time it was so specific that the language that the court used was, did anyone make, or is Miss Reed, you used Miss Reed's name specifically. Is Miss Reed making you take the plea? His answer was no. I don't know. We have to be able to rely upon what a person says at their plea. If we don't, on the first hand, I believe the court system will grind to a halt as soon as it realizes that when something they don't like, they can just change their mind. We'll be back in here on every person who can do it because they'll want to renegotiate from that point. So I think the court has to find that there's something. I realize the standard is simply as an interest of justice, but I don't see what the interest of justice is here other than he now says, contrary to what he told us that morning, that he now says that I maintain my innocence and I didn't do it. I think he clearly gave that up when he offered his no contest plea. And then to say that it wasn't knowing, I don't know what standard this court could possibly do that would ensure a knowing plea more than what it did in this one. So I believe, I don't think we ever get to the issue of whether or not there's prejudice. I don't think that there's enough here. And that's what I've indicated in my response and in my brief. I think the case law, it gives this court great discretion in deciding what it is. And I've cited it directly in there from that I want to stress on the record is that in Spencer, the trial judge should bear in mind what is in the interest of justice in deciding a plea to be withdrawn. And as it says in Goldman, there is no absolute right to withdraw. And so for those reasons, I'm asking you to deny the motion.
All right, so I appreciate the arguments in the briefing, and it's an interesting issue in that I don't recall reviewing a motion to withdraw a plea that was simply as thin and lacking merit as this one. But when I say that, it's because the court went to great pains in this plea taking process. As we've already mentioned, it took some time. We had a jury picked. The court not only asked all of the questions that it's required to under the court rule, I think the court went above and beyond in even asking some of those questions in a different manner, sort of circling back and then even identifying, as has been argued here today, about promises, threats, inducements. Has anybody else said anything about what your sentence may be? Really trying to make sure that Mr. Deakins was comfortable with his plea, that is something that he wanted to do, and every response to questions posed by the court in that plea taking process were in the affirmative by Mr. Deakins. Not once was anything raised in this motion brought to the court's attention during the plea taking process. So I think it's very easy to eliminate the idea that there was a defect in the plea taking process. I just don't see it. I've asked repeatedly this morning for a defect in the plea taking process to be pointed out. That question was danced around, ignored. I don't see an error in the plea taking process. So that leads us to this idea that the court would allow the withdrawal of a plea if it's in the interest of justice and would not substantially prejudice the people because of reliance on the plea. I don't think we get a lot of guidance, if you will, on what is the interest of justice. Now, claims of actual innocence are certainly part of all of that. Blaze is coming from when they try to jail are certainly part of that. But even with this motion in front of the court, as I was looking at it, Mr. Deakins now asserts his innocence. I don't think that a general statement now that I assert my innocence after I've already entered a plea is what the case law supports as far as interest of judgment or actual innocence is what I was trying to say. I don't think that's what the case law means by actual innocence, that now after I've taken a plea, by the way, I'm innocent. As has been pointed out, we would be here on every single case after a plea. If every time somebody asserts innocence after the plea, the court was required to allow them to withdraw their plea. There has to be something more. There has to be. And certainly this court has allowed individuals to withdraw their plea after taking it, but before sentencing. And I'm trying to think of some specifics, and I can't off the top of my head, but there was almost always something that struck the court as compelling, and there's simply nothing here that would suggest actual innocence, just these blanket denials now at the 11th hour. And I don't know how else to phrase it other than Mr. Deakins has buyer's remorse, even though, as we've discussed this morning, he got a very, very favorable plea offer. And I say that in some regard with the benefit of hindsight, having heard from the victims. Now, I recognize that's different than telling their story to 13 or 14 strangers sitting a few feet from them, but they still did it in a packed, open courtroom. And I couldn't help but think at the time, boy, Mr. Deakins made a good choice. Because I certainly wouldn't want a jury to hear those young ladies. And I go on to this when I think about the plea taking process and the allegations today. Mr. Deakins, I don't remember, I've got his plea here because I think this is important. He's 48 years old. Mr. Deakins is a grown man. Mr. Deakins, and part of all of this, and some of the statements I read for sentencing, was active in his community, the volunteer firefighter, all of those things. And all of those things would suggest that Mr. Deakins, as a grown man, as somebody active in his community, as somebody who was, I guess, competent enough and worthy, if we want to use that word, enough to be a firefighter, is certainly the kind of individual that in a plea taking process, if there was an issue in any one of the questions the court posed to him, certainly is the kind of individual that you would think would have the gravitas to speak up and say, wait a minute, judge, I don't want to do this. But he didn't do that. And he had opportunity after opportunity after opportunity to tell the court something that would be in line with what he's indicated here today. And he didn't. And I rely on that transcript in making these findings. I think it was thorough. I think it was complete, and it was in line with the court rule. I don't find that there's an interest of justice here. I don't find that there's any error. Mr. Deakins, please be quiet. I don't find that there was a error in the plea taking process. And this just appears to be buyer's remorse. So respectfully, Mr. Wojcik, your motion to deny, your motion to withdraw, I should say, is denied. All right, so I'm going to ask you to prepare an order that indicates the same so we can track that. And now I believe we can proceed to sentencing. So Mr. Wojcik,